and you can make a difference.
Christians do bring an element of salt and light to contemporary affairs.
Our Lord said that we were to be in the world and not of the world.
If we as Christians will allow God to melt our hearts, the same fire that is melting us will melt those around us.
My conclusion, the answer is yes, Christians can be effective in the public policy arena. And I think there's a wealth of documentation for that. I mentioned in my introduction of Sam Casey this morning that you can look at the Michigan experience and what they've done with the abortion legislation, what they've done with the abortion rate over the last decade. You can look at what they've done with the issue of assisted suicide. If you lived or worked in Michigan back in 1990 when Jack Kevorkian started his crusade, if you will, there were some very dark days when he was just running amok and there was no political leadership. And public opinion seemed to be supporting him, and he was laughing in the faces of pro-life people, and he was a media star along with his attorney Jeffrey Feiger. And it just looked like he was going to become president of the United States. But they turned things around. They turned things around slowly. It's taken about 9 years, but they've had a very effective organization, one of the most powerful and effective state-based organizations in the country. And I think the proof in the pudding is what has happened in the past just 8 or 9 months, where Kevorkian has been convicted finally under a new statute that they passed during those 9 years, and they decisively beat initiative to legalize assisted suicide in Michigan, right in Kevorkian's own backyard, after he mounted his crusade for 8 or 9 years. And it certainly had decisively beating that initiative 71 to 29% had a national impact. It put suicide advocates back on their heels, and they've kind of had a regroup. They've tried to separate themselves from Kevorkian. So Michigan is a wonderful example of progress. You can look at other instances in American history. You can look at British experience with William Wilberforce against the slave trade at the early part of the 19th century. There are many examples where Christians have been effective in the public policy arena. But I think actually Michigan shows that in order to be effective, you must follow certain fundamental rules of communication and leadership. And to the extent you follow those rules and implement them and put them into place, you can be effective in changing our law and our culture. And so I'd like to elaborate on some of the themes that I raised earlier this morning. Then the first one is simply the basic art of communication. We must know our audience, and we must know who it is, and we must effectively communicate to it. And there you can imagine all kinds of audiences. You can imagine witnessing to an individual, bringing Christ to that individual. You would want to know about that individual. You would want to know their makeup. You would want to know where they're coming from, what their religious background is. That's different from speaking to an organization. Let's say you're trying to influence the American Bar Association, or you're trying to influence the American Medical Association, or some state-based health care organization. Who are they? What do they do? How are they run? What is their mission? What are their purposes? It's important to distinguish those two from government. Legislative committees. Testifying before legislative committees requires you to understand the committee, where it's coming from. What are the rules that limit testimony? And of course, it's also very different than to communicate to the public. Remember, Sir Brian Mawhinney last night talked about the soundbite. He said the soundbite is here to stay. And he, the quote from Kissinger, that when Kissinger first entered public service, he was asked what to think. Now he's asked what to say. So communicating to the public is different from communicating to other audiences. And the art of communication assumes some kind of message. And I think that starts with a question of vision. So much in the cause for life, or so many times in the cause for life, I think the whole label pro-life assumes kind of one message and one message only, and it's a hard message. It's either, don't have abortions, or abortion is wrong, or assisted suicide is wrong, and that's kind of the message. But that message is incomplete. It must point to a broader positive vision that can inspire Americans. And even if the message, abortion is wrong, or assisted suicide is wrong, or abortion is bad, or assisted suicide is bad, is true, they must appeal to and become part of, adhere to a broader vision. For example, I would suggest that our vision in the cause for life must be a nation where every child is protected in law and welcomed in life, where strong families affirm women in both personal and professional roles, where the law recognizes mutual responsibility by men and women for child rearing, where a network of services support and affirm men and women and families in child rearing, where family support does not otherwise exist, and where no person's life is demeaned by our law and culture because of age, infirmity, disability, as unworthy to be lived, and where every American can claim the right to life in our Declaration of Independence. That is the broad vision, and that must be stated positively. And perhaps some of the best instances of stating that broad vision have been the DeMoss ads, the DeMoss Foundation ads several years ago that you probably saw on TV, or more recently, some of the ads in Michigan that were shown by a coalition opposing assisted suicide and promoting a positive vision of health care, a positive vision of care for the terminally and the terminally and the chronically ill. You've got to start with that positive vision, and your sound bites have to be part of that positive vision. So communication is a combination of that positive vision with pragmatic arguments. And they complement one another, they work together. For example, when a number of years ago, when abortion clinic shootings and bombings were more prevalent, when they were happening in Boston and other places, there was a tendency by some pro-life advocates to give the media kind of a mixed message. It's, well, we condemn this, but we also condemn the violence in the clinics. And it was a mixed message. It was kind of one of moral equivalence. It was obscure. It was ambiguous. And speaking in the media, that was simply inadequate because it was a muddled message, and you seem to be kind of justifying what they're doing because of what's going on in the clinic. When given the context of the media and the need for sound bites, the need was to unequivocally separate people in the cause for life from what was happening. And the only way you can do that in the media and with sound bites is to unequivocally condemn that violence and separate yourself from it. It's those media sound bites in the aftermath of those clinic shootings did not allow some kind of reasoned moral thesis on violence outside the clinic or violence in the clinic. It didn't allow for it. It was necessary for pro-life people to separate themselves from those acts, and the only way you can separate yourself in the context of the media is to unequivocally condemn it. We must address our culture as it is, not as we would like it to be. It's a culture that appeals to and adheres to kind of utilitarian, pragmatic arguments, not natural law arguments, not Christian arguments, utilitarian arguments. I think, though, that a natural law ethic leads to utilitarian and pragmatic arguments, because when we speak about the natural law and, for example, the rule that virtually everyone adheres to, that you should not kill innocent life, you should not murder, if you talk about violating that law, you ultimately come to talking about the negative effects of violating the natural law. So you start from a natural law principle, and you can come all the way to advocating why the implications of legalizing assisted suicide are negative ones. What are going to be the natural outcome of legalizing assisted suicide? What will be the negative impact on the healthcare system and on patients and on doctor-physician trust and on family members and on the financial delivery of health care? Those are all pragmatic arguments, but they stem from a natural law ethic to begin with. And they basically tell Americans the natural consequences of violating the natural law. They're connected, they're coherent, they're not contradictory. It's also important to understand and have real empathy for our audience. So many people seem to come from a perspective of condemning American culture and American public as naive or immoral, and you can sense a harshness in their perspective. But it's really necessary for us to show some understanding and some empathy for our audience, whatever it might be. I remember that the contrary of that happened when I was at a law school symposium giving a talk some years ago. This was a symposium of lawyers and experts talking about assisted suicide, but it was sponsored by a student group, and it was at a law school. Well, one of the speakers got up, and he started out by criticizing the American, I think it's Student Nurses Association, for supporting assisted suicide. And he said that just goes to show the old adage that students only know enough to be dangerous. And he started out his speech to a student group with that quote. And I started laughing. I just couldn't imagine why he would start out speaking to students with such a put down. He didn't know his audience. Remember what John Kilner said last night about translation and interpretation. I see our role at Americans United for Life as largely translating the natural law into terms that the public can understand. And those are largely utilitarian and pragmatic terms. We also must know, as part of the art of communication, must know the rules of the institution that we're addressing, knowing how things operate. In 1991, we were involved in a campaign in the American Bar Association's annual meeting to keep the American Bar Association neutral on the issue of abortion. It was in 1991. That's before the Casey decision in 1992. And our theme was neutrality. We wanted to keep the ABA neutral. We weren't arguing that they should go pro-life. We wanted to keep them neutral. We wanted to keep them from going pro-abortion. Well, I'm not an ABA, I was an ABA member, I suppose, at the time, but I wasn't influential in the ABA. I wasn't official in the ABA. But we had, our team was led by officials in the ABA. They knew, where the skeletons were. They knew where the rules operated. They knew the parliamentary procedure in the ABA. And with that knowledge and our theme of neutrality, we prevailed in 1991. But a year later, in 1992, we lost in San Francisco. They put the ABA convention in San Francisco. They manipulated the rules better than we did. They were able to put on more speakers than we were, and the ABA got off of neutrality and adopted a pro-abortion position. And we lost because we didn't manipulate or operate cleverly within the rules of that institution as well as they did. Look at the example of Jeffrey Feiger. Jeffrey Feiger is Jack Kevorkian's attorney, or was his attorney in Michigan for a number of years. Jeffrey Feiger knew how to work the media. Jeffrey Feiger is a trial attorney. He knew how to speak to juries. But Jeffrey Feiger was not an appellate attorney. And every time he argued an appellate case on the issue of assisted suicide, he lost. In fact, he was found in contempt of court by the higher courts in Michigan because of his activity in the lower courts. He won in the media. He won before several juries. But he lost on appeals in cases involving assisted suicide, and he was given very little respect by the higher courts in that state because he didn't know how to address, he didn't know how to translate the trial jury approach and his aggressiveness to the more cerebral institutions of higher courts, appellate, and Supreme Courts. It also, for example, just requires you to understand sometimes the law and how it operates and the limitations of the law. For example, Sam was referring to protection for embryos that are ex utero, or embryos that are out of body, or extracorporeal embryos, embryos that are not implanted. Well, it's not well known by Americans that although the Supreme Court's decision in Roe versus Wade and Planned Parenthood versus Casey addressed abortion, it said nothing about the killing of the unborn child in non-abortion circumstances. Roe versus Wade says nothing about the drunk driver who careens down the street, kills or injures a pregnant woman, and kills or injures her unborn child. It says nothing about the bank robber who's into a bank, shoots wildly, strikes or kills a pregnant woman, kills or injures her unborn child. It's possible in the law today to protect that unborn child at every stage of development, at every stage of gestation. There's a law today in place here in Illinois. It's been in place for almost 12 years now, which protects the unborn child at every stage of gestation outside of the context of abortion, from the drunk driver, from the bank robber, and prosecutes the killing of the unborn child at every stage of gestation. And yet it coexists with Roe versus Wade and abortion on demand because of the limits of Roe versus Wade. Most people don't understand that. We've been able to work that to our advantage by passing legislation in Illinois and other states. Now, today, 29 or 30 states protect the unborn child at some stage of gestation outside the context of abortion. And in the public arena, of course, we must deal with the force of public opinion and garner majority support for any policy proposal. We must mount a constant and civil public argument. Over and over and over again, that must be our theme. A constant, it must be repetitious, it must be persevering. We must mount a constant and civil public argument. We can't be screaming at people, we can't be condemning people. It must be a civil public argument. That is what's going to win the day. Now, there is a utility for different roles. And there is a utility for people who are, very absolutely strongly principled and will not equivocate in any instance and are always holding up that absolute principle in its most pristine and pure form. But there's also a role, a legitimate role, for people like MP Surmawani in working the levers of legislatures and reaching progress in public policy. I have an article in a recent issue of Christianity Today that deals with public opinion as it is on the issue of abortion, the myth of abortion as a necessary evil. And I'll pass that out at the end of this session. It summarizes our public approach to the issue of abortion. The fact that Americans see abortion as an evil. 77% see it as at least the taking of human life, if not murder itself. But even though they see it as an evil because it's the taking of human life, they see it as a necessary evil. Why necessary? Our challenge is to unpack this myth of abortion as a necessary evil and to target our educational efforts at dispelling the myth of abortion as a necessary evil. It's also necessary to define differences. We must identify and define differences between candidates, between policy positions, in order to pass legislation in the states or in order to win elections. It's necessary to urge people to make a choice. And in order to urge people to make a choice, you have to distinguish, you have to define differences between those two choices. And I enjoyed what Sir Brian said last night about praying with political opponents. I think that's wonderful. I think that should be done. But it's no contradiction to leave that prayer meeting and to go out and rail against their position on political issues. There's no contradiction there. I mean, he was talking basically about the boundaries of civil discourse. There are some limits on civil discourse. But there's no contradiction in praying with political opponents, being friends with political opponents, and in the public realm pointing out why their policies and their positions, even if you don't get personal or don't attack them personally or don't get overly heated in your rhetoric, but to point out why their positions are wrong and why they will yield negative results for American or British society. There's just no contradiction there. We must also focus on specific, realistic changes in policy to garner focus on the bigger issues. Because debate over specifics, partial birth abortion, parental consent or notice, women's right to know legislation, clinic regulations, debate on those specifics moves the broader issue of abortion generally. Because when you debate the issue of women's right to know, you're basically debating the issue of how much information women should have about abortion. Well, they should have as much information as possible about the nature, risks, and alternatives to abortion. If you focus on informed consent or women's right to know legislation and the specifics about that, you're always going back to the broader issue. What is abortion? What are its risks? What's the nature? What are alternatives to abortion? So debate on those specifics moves that broader issue. Debate on, for example, this week in Congress, debate on penalties, whether you can sue your HMO, allows discussion on the broader issue of what kind of a healthcare system we want in this country. What are its benefits and detriments, strengths and weaknesses, and how can we have a system that provides the best possible care to as many people as possible. I'd like to comment a little bit on the question of compromise. Unfortunately, the issue of compromise, as raised by Sir Brian last night, is the term compromise is usually an epitaph. It's usually something you charge somebody with doing. You're compromising. Well, anyone who has read the Hanukkah story of the Maccabean revolt under Antiochus Epiphanes knows and understands the imperative to resist compromise on fundamental moral principles. That's what that story is all about. That's what that history is all about. But I think, unfortunately, there's been a tendency in the Cause for Life over the last 25 years to water down the meaning of compromise by labeling as compromise many types of important legislation, like the ones I've mentioned, informed consent, partial birth abortion, that seek to limit abortion whenever it's not possible to ban it entirely, and to label this as compromise. But given the constitutional and political obstacle of Roe versus Wade, as Sam outlined, this legislation is both morally appropriate and it's strategically necessary. And I think the important factors to consider when you think about compromise, what is compromise? Is this decision compromise? Is that decision compromise? It's important to think about power, intention, and perception. The whole notion of compromise imagines kind of a group of people meeting in a room and saying, well, you can kill 10 babies if we'll save 90, or you can kill 40 babies if we'll save 60, or something like that, as if that's the way legislation is crafted. Where the reality is that for the most part, you're fighting against a opposing power and fighting tooth and nail for as much as you can get. And you're fighting tooth and nail for majority support. You know, you start out with 30% on this side and 30% on that side, and you're arguing with the 40% in the middle. And you're trying to get enough of the 40% in the middle to get a majority to pass some legislation and make some progress, step by step. The intent of such incremental legislation is obviously not to endorse abortion or Roe versus Wade, but it's to limit the evil of abortion and the evil effect of Roe versus Wade. It usually has three primary purposes. Some legislation of this type seeks to protect principles like parental authority or informed consent that we can protect. Some seeks to limit the evil by limiting the number of abortions as much as possible. And some seeks to push the outside of the envelope and to limit abortion in such a way as to challenge the authority of Roe versus Wade and to create test cases. These state regulations in this way recognize the power of Roe versus Wade without recognizing the moral authority of Roe versus Wade. There's a difference. Roe versus Wade has power because it's constrained the ability of public officials to prohibit abortion over the last 25 years. It may not have any moral authority, but it has power. Hitler had power. He may not have had moral authority, but he had power. Power enough to kill 6 million Jews. Stalin had power, but he may not have had moral authority. There's a big difference, and you've got to distinguish between those two. And you can't ignore the moral authority, you can't ignore the power that someone has. And recognizing that power is not recognizing their moral authority. It's not compromising. to recognize that that power is a fact that you must get around. And the purposes of this legislation are publicly known. There's no secret about this. In fact, that type of incremental or regulatory legislation has been documented in a book that we published in 1987 called Abortion in the Constitution, Reversing Roe versus Wade in the States, reversing Roe versus Wade through the courts. And no informed person could get the impression that that kind of legislation admits the moral authority of Roe versus Wade or endorses abortion. In fact, exactly the opposite is true, because that type of legislation is always usually condemned as, quote unquote, the first step in banning abortion. Pope John Paul, in his encyclical Evangelium Vitae, really summarized this whole issue very well. He said, when it's not possible to overturn or completely abrogate a pro-abortion law, an elected official whose absolute personal opposition to procured abortion was well known could licitly support proposals aimed at limiting the harm done by such a law and at lessening its negative consequences at the level of general opinion and public morality. This does not, in fact, represent an illicit cooperation with an unjust law, but rather a legitimate and proper attempt to limit its evil aspects. And that, to get back into the phrase of compromise, that summarizes the real situation and the necessity of distinguishing between power and moral authority. Some of these problems that we have are broadly based cultural, social, and political problems. Certainly abortion is deeply ingrained in our culture over 25 years. Back in 1973, abortion on demand was legal in a number of states, but it wasn't legal in 50 states until the Supreme Court's decision. 15 states between 1966 and 1973 legalized abortion to some extent or another. But in 1973, the Supreme Court wiped out all the rules on all the laws on abortion and legalized it throughout the country in all 50 states. That dramatically changed the situation. But at that time, abortion was not deeply ingrained in the culture. And the problem was essentially the Supreme Court, because just a couple months before, a number of states had rejected legalization through referendum, Michigan, North Dakota. But 25 years later, it's become a deeply ingrained problem. Human cloning, on the other hand, is not a deeply ingrained social and political problem, because it hasn't been around. It's still science fiction to some extent, even though the scientists may be able to do it this year or next year. It may be coming down the pike, but those are very different issues and very different problems. And the broadly based nature of abortion requires a correspondingly broadly based approach, whereas public opinion in banning human cloning is probably 80 or 90%, and if you could pass a federal ban, I think you would take care of the problem rather easily. Two issues are very different because their natures are very different. All of this assumes that we have to plan adequately to succeed. You have to strategically plan. You have to have a plan to have a conference like this, or to draft and publicize a statement on stem cells, which the Center for Bioethics and Human Dignity did in the last month. Have a press conference in Washington, get those distributed to 435 legislative offices, 535. You have to be able to plan to succeed. And the better planning you do, counting the costs, counting everything that's going to have to go into implementing a successful plan, the better planning you do, the better you can succeed. And of course, you have to have sufficient resources at your disposal. The Christian Legal Society combined with the Center for Bioethics and Human Dignity to distribute that stem cell statement to 535 legislative offices. That took a lot of people. They had to plan that out, and they had to have the resources. If they'd shown up with two people that morning, they wouldn't have gotten it distributed to 535 legislative offices. They had a plan to do that, and they had to have the resources to do that. And the question is, do you have the capacity to implement the plan that you create? And capacity is a question that I must confess has kept me awake many nights over the past 10 to 15 years. It's something I wrestle with every day, resources and capacity. But none of this is going to succeed. None of the foregoing will lead to success without perseverance. And the more experience you have in the public policy process, the more you realize that you have to persevere. People who are rookies and just get into the public policy process may think that you go down to the state legislature, you have some legislative testimony, you go to a committee hearing, and you pass a bill. It's not the way, it doesn't work that way. I mean, sometimes it works that way, but it doesn't often work that way. And states like Michigan have had to persevere year after year after year. Look at Texas. Governor Bush just signed a parental notice law this year. First time since Roe versus Wade that Texas has had a parental notice or parental consent law. They've been working for 25 years. And of course, Texas is a strategic state because it's one of the top 5 in the number of abortions. You know, and one of the top 5, obviously, in population. It's a key state, but they worked for 25 years. When I think about perseverance, I think about my daughter's, Caroline's, soccer team. I have 5 daughters. Caroline is number 3. She's 8 years old. She's been playing soccer for about a year. And at 8-year-old soccer, there are a couple of keys. You got to get the ball down the field, and you got to kind of energize the girls in front of the goal to have somebody who is tenacious enough to kick it into the goal. And those are the 2 things you really need. And there are some girls at that age, and they can be of all sizes, but there's some girls who just kind of like kick the ball and kind of like watch it. And they just stand around and kick it and let somebody else kick it. And then there are some girls, and they can be the smallest on the team, and they'll just kick it and kick it and kick it, and they can run all the way up the field and get in right in front of the goal with that ball. And they may be the shortest kid in the team, but they're just tenacious. They persevere. They kick it and kick it and kick it. And it's essential. Look at finally, look at the experience of William Wilberforce in Great Britain. He spent his entire parliamentary career, 48 years, fighting to limit the slave trade first, and then abolish slavery altogether in the empire. And at the same time, he was leading a corresponding crusade to change the manners. That was the phrase they used. It was really to change the morals of England, primarily among the upper classes. He succeeded in both accounts. But he worked for 48 years, first banning the slave trade and then banning slavery. And Parliament didn't vote on a ban on slavery successfully until 4 days before he died in 1833. He spent his whole life on that issue, and he persevered. So this is not for the faint-hearted, and I urge you to persevere in your own arena, to persevere in the things that you can do, because we can change law and culture, but it takes perseverance. Thank you.